Good evening, ladies and gentlemen. Welcome to the Washington County Services Committee meeting. On the agenda, we have the prayer and pledge to be done by Justice Rivera Lopez. Justice Lopez.
Thank you. Lord God, I ask that you be in our thoughts and in our understanding as we look to lead better today. I ask that you watch over everyone here in attendance, everyone who serves on this horseshoe, and all the citizens and people who inhabit Washington County. Lord, I ask that you give us the strength to make the right decisions, to make good decisions for our constituents, and to care for one another as you care for us. In Jesus' name I pray, amen. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Justice Rivera. Next on our agenda is the adoption of the agenda. So moved. One moment, please. There we go. I recognize Justice Washington.
Thank you, Madam Chair. I would like to amend the agenda to add item number 6, the chairman's report.
Thank you. Do you have a motion? Do I have a second? I have a second by Justice Rivera. All in favor? Aye. All opposed? Do I have a motion to adopt the agenda as amended?
Make a motion to adopt the agenda.
I have a motion by Justice Dean and second by Justice Lemming. All in favor? Aye. All opposed? The agenda has been adopted. Number 4 on our agenda is a juvenile detention report by Director Tinsley. Good evening, sir. How are you?
Good evening, Madam Chair. I'm doing great. This is the Juvenile Detention Center report for April 2025. This report is covering 24 days of data. In the month of April, we had 19 intakes, with the average length of stay being 41.35 days. The average daily population for April was 19.16. The highest number of intakes was battery second-degree felony at 7. Of the 19 intakes from Washington County and Madison County, 11 were from Division 3 and 8 were from Division 8. There were 9 total transports. 5 of those transports, were performed by the Washington County Sheriff's Office, and 4 were performed by the Washington County JDC. Are there any questions that I may address at this time?
Does anybody have any questions? Seeing none, have a good evening, sir.
Thank you, Madam Chair.
Thank you for a report.
Yes, ma'am.
Next on the agenda is the Sheriff's Office report by Sheriff Cantrell. Good evening, Sheriff. How are you?
Thank you, Madam Chairman, and I'm fine, thank you. The Sheriff's Office report, I think, is in your packet. Calls for service for our Enforcement Field Services Division is up a little bit, but nothing out of the ordinary that we see here. Detention intakes are actually down a little bit over the prior year. We sent about the same amount to prison. Our daily count as of today is down a little bit, and I attribute most of that, I think, to the work that Judge Bryan and Judge Taylor are doing to work through our pretrial population. That number is down. You can see the average pretrial, average daily population is down about 50 from where we have been, so we're encouraged by that. Our overall count still higher than we'd like to see it. Still have 108 people sleeping on the floor, but that's better than 158 that we have seen. So, you know, I'd be happy to answer any questions anyone might have about the Jail or the Sheriff's Office report.
I have Justice Lemming.
Thank you, Chair. Jay, how many active warrants do you know Washington County have on record right now?
Oh, J.P. Lemming, I don't know the exact number. I know there's about 40,000 felony warrants out throughout the state, but I don't know how many Washington counties. I can get that number for you.
Well, I had lunch with Larry, the county judge over in Madison County today, and he was telling me they had 3,000.
Yeah.
They're just a little community too.
Right.
And he said also his jail's gonna open here in just a few days and have an open house, and he invites us all to come see it.
Yeah, I heard that they were going to open up a portion of it.
Yep.
And,
But I'd like to know that number.
okay, I'll
Thank
get that
you.
number for you.
Are there any other questions for Sheriff Cantrell? I have Justice Koger.
Thank you, Madam Chair. Sheriff, I was just wondering, what about the number of positive COVID cases you have at the jail?
Today, we don't have any. So
No,
we're
so
at
no
0
one's-
today.
Okay. And what is the head count for today? I didn't check it before I came.
Let me look. At 2 o'clock, when I printed off my, the most recent report, it was 748.
Okay, that's down a bit too.
Yeah, it's down a bit, yes.
So what, does that include restrictive bookings?
There are no restricted bookings as of this number.
Okay. And what about the number of 309s?
41 total.
Just like last month, okay?
Yes.
And how many vacant positions do you have in both in enforcement and detention?
28 in detention and 4 in enforcement.
Okay, those numbers are down too then, so.
Yes.
And I'm glad to see the pretrial average
Yes,
daily
yeah.
population being down. Thank you very much.
Are there any other questions? Thank you, Sheriff. Have a good evening. Okay, next on the agenda is the chairman's report. This past Saturday, I attended the AAC annual quorum court meeting. There's a representative from all 75 counties, and on a beautiful day, it was great to see 65 counties represented. So the things that we discussed were the legislative bills that were just recently passed by the legislature and signed by the governor. The one that affects us as quorum court members was the amendment to the FOIA bill. And I know it can be frustrating when they don't exactly define what a meeting is. What do you mean by a meeting? And usually the definition doesn't have the word meeting in the definition when you're trying to define what a meeting is. So I'm just going to give you a brief statement of what they have come up with. So what is the current status of open public meeting laws in Arkansas? Frustrated by the lack of absolute clarity of what constitutes a meeting, Arkansas lawmakers attempted to define a public meeting in the recent legislative session. Senator Alan Clark filed one which would make it virtually any interaction between two members of a governing board other than a chance interaction, a public meeting, regardless of the topic of discussion, and not exempting social gatherings, athletic events, church gatherings, picnics, etc. That's a public meeting according to them. On the other end of the spectrum, Representative Mary Bentley filed one with HB 1610, which would have defined a public meeting as a quorum of a governing body, later being amended to no more than 1/3 of a governing body. Both bills failed. So where are we as a result? We're left with a vague statutory definition of a body of case law that has shifted some parameters. Telephone polling and serial one-on-one meeting solicitations for response for the purpose of subverting a public meeting are clearly a violation of FOIA. And then, I didn't get you all the bill, but I will show you. We are not allowed to communicate with one another for the means of taking a poll of, are you going to vote in favor? Are you going to vote against? well, I'm going to vote against. I need 5 more votes to vote against this. That is in direct violation of the FOIA, the new FOIA bill. Okay? You cannot ask or determine how you're going to vote. Then later on, they did, in the bill, page 10, it says F. It says, a member of a governing body shall not participate in a communication, whether oral, written, electronic, or otherwise, that he knows or is reasonably should know that it's a poll. Just don't even participate in any of that, and you're fine. But it did say, and later on I'll get this to you, page 11, line number 5, it is not a violation of subdivision of this section if a member of a governing body communicates background, non-decisional information to one another or to more members of the same governing body. If you're just saying FYI, or I need some information, how did you see that? Did you interpret that as this? If it's just information gathering, you're not violating FOIA, according to this new bill that was passed. And that's pretty much in a nutshell what the new FOIA law is. I mean, there's other things you can go as deep as you want, but I felt if those things don't do this, and this is not a violation. Is there any other comment or discussion on that? Okay, the next one is, has to do, well, you have in your packet, I passed out the new currentness of the quorum court procedures, and that is ACA 14-14-904. And that will bring us up to speed on what our quorum court procedures should be like. The other handout I gave you is 25-19-103, were the definitions that were given to us regarding the bills that were passed, just to be clear that we all understand what that is. One bill that it's still HB 1958 is an extension to the AI policies, and this is being developed by Brandy McAllister of the AAC. We're all going to have to adopt AI policies. So what I would like for all of us to do is to review this information that I passed out, and at our next meeting, if we care to have a discussion on it, we can have a discussion so that way we're all on the same page and not kind of wondering, how did you know that, how did you didn't? Is that good? Okay. Moving on, next on our agenda is item number 7, an ordinance requiring advance notice of the quorum court of appointments to the county boards and committees. This is introduced by J.P. Koger. J.P. Koger?
Thank you, Madam Chair. So for members of the community who are either present here today or watching from home, who aren't familiar with the process of how we do appointments to committees and boards, I'd just like to provide some background information regarding this, that, and my proposed ordinance. Arkansas Code 1414-1102 B1 gives the county judge the power to make appointments with the approval of the quorum court unless otherwise provided by law. So in summary, the county judge appoints, the quorum court confirms or approves, unless another law says otherwise. Currently, in Washington County, it's been standard practice since at least 2019 that the county judge presents a nominee to the quorum court, always followed by an immediate vote to confirm the appointment. We aren't given the opportunity to speak or debate. We, members of the Quorum Court, receive no advance notice of the appointment and no information regarding the nominee's qualifications or experience. This process results in the routine approval of appointments without meaningful review by the court. For this reason, I consistently vote no on appointments. This whole process of advance notice could be something as simple as providing the court copies of the nominee's online application to serve on whatever board or committee they want to serve on. Advance notice enables members of the Quorum Court to conduct appropriate due diligence and allows us as elected officials to demonstrate accountability to our constituents. Since Arkansas law entrusts the Quorum Court with this responsibility to confirm appointments, I believe that trust inherently includes the duty to review and assess the qualifications of appointees prior to just voting yes or no. This ordinance tonight aligns with that statutory framework, and it strengthens the confirmation process by providing information on appointees so that we as JPs can make informed decisions. It will support public confidence in the integrity of county government. It will ensure that appointments to Washington County boards and committees reflect the qualifications, diversity, and needs of the community we are elected to serve. Specifically, Arkansas Code 1414-1102, Section 4 provides that the county judge shall be responsible for the administration and performing the executive functions necessary for the management and conduct of county affairs, as prescribed by ordinance of the Quorum Court. So that's why I think my ordinance is proper, and I make a motion that we approve this send this on to the Quorum Court with a due pass resolution. Thank you.
I have a motion by Justice Coger and a second by Justice Hires. Is there any discussion on the motion? I have Justice Lemming.
Thank you, Chair. With the ordinance like this, if we don't put time, you said 5 days, business days prior to any scheduled meeting, that could conflict with maybe, I just see that being an issue to a degree where maybe timeline matters, and I think the county judge and the attorneys and everybody that they appoint, I think they know them and they study them pretty good before they bring them to us to be voted on. I just don't think we need this, and I just don't think we need to set ourselves up to more legal battles that could happen in the long run. I just think it's not needed. Thank you.
Thank you, Justice Lemming. I have Justice Lopez. What happened?
Judge, can I ask you to answer a couple of questions? Thank you.
Thank you, Judge, for being here.
So obviously I don't think we want to impose on your process, but how often would you say that your decision for who is going to be appointed is already done before those 5 days prior to?
I would say about 50% of the time.
50%
A lot of times these are time-driven. What I'd like the Quorum Court to understand too are there's appointments that come to our office that are not underneath our purview, if you will. Library board appointments. The Board of Equalization is a great example. We're going to have some appointments to that this month. We think we're reappointing those that you guys confirmed in January, but when we read the state law, it says you must do that in the month of May. So we'll bring those back. So what I'm saying is the Board of Equalization brings those recommendations to me because you guys have an appointment to that board, the school districts have an appointment to that board. Maybe more broadly, if I could answer your question, I have no issue ahead of time issuing these names and what I believe the qualifications or any given board are. The 5-day timing is a little bit. I would like to just do this, not through an ordinance, but let's honor one another and do this as much as we can. Here's my next concern, and I find it interesting that the justice that sponsored this ordinance brings that That brings me a lot of concern that she's the one that does this. And she crows and hides behind transparency all the time. I believe I've had this discussion with Justice Rios Stafford in private about why will I not issue those names ahead of time. We have nothing to hide. Many of those, once again, aren't necessarily my personal appointments. They're just people that I think are good. We also have an incredible hard time getting people to serve on boards. They're hard. You guys understand that from your work. You know, they don't pay extremely well. They're very demanding of your time. But there's one major tenet that really concerns me. And that is that when we hired Nabholz to do the COVID mitigation project at the jail, Justice Koger and her organization, Arkansas Justice Reform Coalition, FOIA'd all those materials. And then they initiated a public-driven campaign to essentially harass those individuals. They sent them emails and messages, just basically trying to get them away from that project to where Nabholz would walk away from it. I don't think that reflects well upon our county, no matter what your political opinions of the jail are. I think we still want to be able to attract and contract with very reputable businesses. And of course, that is a business. That's a big corporation that has a financial interest in working with the county. I'm really worried for those same types of tenets and actions to come down to an individual level for a potential board member that might join our group. And I think, you know, some might see that as hyperbole, but I very much think that that's a big concern, and we have seen that played out absolutely for sure. We have seen those kinds of tactics. And so I would love to work with you, ladies and gentlemen, and submit those ahead of time. I would love some grace about that. What I will do is I will send those to you as soon as we possibly can. I guess I know that's not a very good answer for you, but you know, the indeterminate times would be a challenge, and we'd like to do that. But I'd also like some trust and some honor back from the rest of the board here to say, these are individuals, they have private lives, they're volunteering, and we certainly don't want to harass and terrorize these individuals, as has been the past actions of some.
Right. And if I may, a follow-up question. I understand that maybe a decision hasn't been made. How often or how early do you have finalists for a position? Would it be the same, roughly, that same period? Once you have finalists, you kind of have an idea of who you're going for?
I would back up and say, I think your question assumes that there's a pool of people that apply for any one post.
That's fair. I'd say that's a fair.
And that's not what we continually see at the county.
Gotcha.
We usually see the individual who applied is brought to you, ladies and gentlemen, and confirmed, because we're so glad to have them in that position. Does that make sense? We're so glad to have them to have volunteered and applied here.
Yes,
Yes,
sir.
sir. So this is off the cuff, so please trust me. I don't think I've ever chosen from a pool and had several that we did not decide. Does that make sense? Like
Yes,
it was the person who came and vetted for the position. And really, to be honest with you, ladies and gentlemen, and it'd be interesting to turn the question around on you on what criteria you're going to use to select and vet these individuals. I'd be much to know. To be honest with you, if they have experience and credibility that goes to any of the role, even indirectly, those people at the end of the day are still citizens and taxpayers. And so it's hard for me to say, hey, you're not a realtor, you can't be on whatever board. I'm taking the populace as it comes. And so usually you guys see those applicants and you're confirming those applicants. We don't have a pool that we have denied, if you will.
Okay. Thank you, Judge. I appreciate your time.
Thank you, Judge. I have Justice Bruns.
Thank you, Madam Chair. I would like to make an amendment, if we could. Throw this out, that if we have somebody who applies, that it gets included in our packet. Not necessarily we have a 5-day, 3-day, whatever day. It gets included in our packet prior to us voting on it. And, excuse me? Oh.
I have a motion and a second to making that amendment to, can you state that again clearly?
Oh, well, you're asking a big thing here.
I know, think.
I would like to see us submit the name of an applicant, same time we get in our packet the,
So you want the name of the appointee,
I want the
person
name and
that's-
the information on the appointee. At the same time, we receive our packet on a Friday prior to us voting on it.
Okay, I have a motion and a second by Justice Stafford. Is there any discussion on the amendment? I would say, let's not even have an amendment and just work with the judge's office and request it without having to go through a legislative ordinance. The expense of an ordinance, the possibility of opening the county up for a lawsuit if it's not done exactly the way somebody wants to have it. So that is what my thought process is on this. So you still want an ordinance?
I just think we need an amendment to the ordinance stating such. The ordinance, I don't have a problem with. I don't see that big of a deal with attorney issues down the road with appointee, especially if we're gonna have one appointee that we're begging to come volunteer. I think it's a good thing that we get it early and we get to make a decision. That's the intent I think Justice Coger has had with this, that we get the information so that we can make an intelligent vote.
Okay.
And that's only fair to us.
Is there any other discussion on the amendment? Do I have, okay, next is Justice Lyons.
Thank you, Madam Chair. Judge, if you don't mind. A lot of minds think alike, and I was going to similarly just interpret what I think you're saying is, again, if you agree to put it in the packet would be acceptable to you versus 5 days. You said you'd publicize it somehow. If we just say, let's do a packet, that's what you agreed to, is that acceptable from your
Yes,
perspective?
it is. I think we want to appreciate, sometimes our board members don't apply online. You know what I mean? There's not a uniform process. And once again, what I will tell you is, I'm not the custodian of this information. These appointments come to me. You know what I mean? So just as long as you're going to communicate to everybody else who has interest in these appointments, that they'll need to get our office that information. You know what I mean? Ahead of time. I mean, there's a good sum of these that we don't, my office handles only to bring them down here and submit them to you, ladies and gentlemen. I hope that can kind of make sense.
But it would make sense that, do you normally know by the time the packet comes out that we're going to have that?
Yes, I
And
don't
so it
think.
could be an agenda item, we're going to do this and this is the
Correct.
information. Okay.
That's not really what I was.
I just trying to.
I just want to say that the information that we get is not uniform.
Right.
You know what I mean? Like, some people will give us a resume. Some people will just type up an email about their qualifications. They're not comfortable having a resume. Some people actually go through the online application process that we have set up. So you'll have that. We'll give you whatever we
Well,
have.
and that's the point. In the packet, here's who it is. Whatever that you got from them is what.
Yes.
Sure.
With the trust that we'll please be respectful
Yep,
to these
okay.
individuals.
Thank you.
Thank you, Judge. I have Justice Wilson.
Are we exclusively talking about the amendment? or-
About the amendment.
Well, I have other comments, but I can save those for later. Concerning the amendment, I'm not clear if this amendment were added, if it goes in there in addition to all the information that's already there, or does it replace some of the articles that are there? I'm not clear on that, so I don't know what we're voting on if we voted on this amendment.
Okay. I have Justice Pond.
Yes, and we're talking about the amendment only,
Correct.
and we already have a word from the county judge that he will be including the information in the packet. That's not to say there may be times when, like when it's other, entities that actually bring those appointees to us. He's gonna have us that information whenever it's possible. I'm gonna work on the trust that he's gonna have that. So not that I've got anything against the idea of the amendment, which I don't. I just don't think it's necessary to make a law for every single thing we think ought to be done. I heard a fellow say one time that we wouldn't have to have so many laws if people would just abide by the first 10. So I'll be voting no on this. Thank you.
Thank you, Justice Pond. Next, I have Justice Coger. Where are you? Why does that happen to you?
That's me.
Justice Stafford. Okay, wait a minute, hold on just a second. I've got Justice Coger. There, it's on. Yes, you were next.
Thank you, Madam Chair. I'd just like to say the reason that I chose the 5 days is because that's the deadline that we have for putting items on the agenda. So I thought that kind of fit in nicely with that. And of course, we have an ordinance that we can always vote to suspend the rules if that becomes necessary. If there should be some last-minute information or appointment, we can always vote to suspend those rules. That's all.
Now, we're talking about the amendment.
Right.
Okay. Justice Stafford, my apologies.
That's
Thank you.
okay. Thank you, Madam Chair. I'd like to make a friendly amendment if JP Bruns is okay with it, just to clarify kind of what he's trying to say and what the county judge has told us. And also for kind of to answer JP Wilson's question. What I think we're trying to do here is in Article 1 to say, the county judge or his designee shall notify the quorum court of any intended appointments to county boards, commissions, or committees in the quorum court packet prior to any scheduled meeting of the quorum court or any of its committees at which the appointments may be discussed, considered, or confirmed. And here's the important part I want to add, if such names are available. So we're adding that only if the names are available. And we're not putting a time limit on it. We're saying it just, please include it in the packet.
I have a motion to amend the amendment. And it's a friendly, if
Yeah, it's,
Justice Bruns will,
okay.
okay. So that's how it will be. I have Justice Pond.
Oh, that's all I had.
Okay. Justice Lines.
No, my colleague got it. It was very unclear. The intent of what the amendment was noted, but exactly what we were changing wasn't. So that's what I was going to ask for.
Okay. Justice Wilson?
I think really I'm still on from earlier. I didn't have anything else to say concerning amendments.
Justice Massengale?
Yeah, I really like the idea of having all this information available ahead of time, but I'm kind of like Justice Pond. I don't know that it's necessary that we do this. We can always vote no if we feel like we don't have enough information at the time, so I think it kind of works both ways. It'd be to the advantage of the judge to give us that information ahead of time so we can, make an informed decision. So, I mean, I like the idea of this. I just don't know that we need to write a law for every little, that could apply to anything, a lot of other things that get added to the agenda. So, yeah, I felt a little blindsided. I think at the last meeting, there was a candidate that was, we voted to, I think, the Planning Commission. And I didn't know who the individual was, but
I think it was a last-minute nomination. And things like
Right.
this happen. Sometimes you don't get the information in time to get it out. And that is one concern that I do have, in passing an ordinance because it becomes the law. And if there's a violation of the law, somebody can sue the county because we did not follow the law as is. So, are we ready?
Yeah, I was
So
just
go
saying, so I
ahead.
had an option, I could have requested more information or voted no on that
Yeah,
nominee.
we could have
so-
said, can you give me a little bit more background information? And that is on us, and that is not on the county judge. I have Justice Lopez.
I agree to an extent, but I think that we get caught up in this minutia of, should somebody not follow the law? And I think the conditional that Rio Stafford provided was very important for that very distinction. It's if that information is available. So if that information is not available, then we're fine. It's not that every appointment is going to have this. It's if this can be met, that we meet this standard. And I appreciate having the judge's word. I do think that counts for something. But again, we are assuming that we are always going to have a judge who is comfortable with that agreement, with that gentleman's agreement. And that's not really what I think the goal of a legislative body is. It's to make and set standards for how we should conduct things moving forward. And again, that is, I think the judge absolutely will live up to his word, but I don't know what the next judge or the judge after that, how they would interpret
Well, we
this.
do have to, it has to be brought to us, period. And we're the ones that ultimately vote on the approval or the denial of the person. It's our,
I understand that. I
our
just think
vote.
it's good to have that information earlier.
But it
I
is
understand the
minutia.
sentiment
I
from
think we
everyone.
are getting into the
do
minutia
agree.
of laws, and I would rather work together collaboratively to get this forward. Give them an opportunity to do this, and without having to pass an ordinance. Who do I have? I have Justice Rio Stafford, I do believe. Are you next? No, okay. Justice Lemming.
Let's call the question on the two amendments on the floor.
Okay, I have a motion. All in favor for the amended version, say aye. Oh, my apology. No. I have a motion, and I have by Justice Lemming to call the question. I have a second by Justice Ricker. All in favor? All opposed? I have the president calling me, Tommy Young from Jefferson County. Thank you. All in favor, say aye. All opposed? The question's going to be called. All in favor of the amendment, Justice Bruns, do you have a comment to make? Okay. All in favor of the amended version of the ordinance, say aye. All opposed? No. Let's do a show of hands. All in favor, say, raise your hand.
This is just to amend.
This is to accept the amendment. Y'all are so bad, and nobody can see that. All opposed, raise your hand. 1, 2, 3. The motion to amend passes. Now, are you going to make a motion to accept? The amendment was accepted. Now we have to make a motion on this ordinance, whether we're going to. Okay.
You just amended it just then.
On the amended version. Who made the motion?
Does your motion to pass this ordinance as amended still stand?
I can't hear from both. I'm sorry.
We have a motion to amend we amended it. Now we need a motion to pass.
Okay, motion to pass.
Okay. I have a motion by Justice Coger to pass, and I have, who's the second? Justice Hires? Is there any discussion on the motion? I have Justice Wilson.
Thank you, Chair. Within this ordinance is a reasonable request. I think probably everybody concedes that. With the amendments that were added, I think they were reasonable amendments. But I will say, when you take that and couple it with the fact that informally we have a handshake agreement that the judge said, I don't mind providing additional information and providing it in a timely manner when it's possible, if it's at all possible. And it seemed like several people sitting here were very receptive to that. So it looks to me like informally we already have an agreement if we didn't do anything. It looks like the concerns that this ordinance attempts to address are already being addressed just in an informal conversation during this meeting. So when you take that and we also look at, in particular, Article 2 and Article 3, and I'm not the legal scholar here, but I wonder if we want to go down the road of putting stipulations on a constitutionally elected officer. Maybe we can do that legally, maybe we shouldn't. But either way, I don't know why we would want to go down the road and pass this as it is. So I can't vote in favor of it for all of those reasons, but it still looks to me like any concerns that are in the room on this issue, it's going to work out fine. If not, someone could probably craft something similar to this 6 months down the road or even a year down the road. But it doesn't look to me like, it looks like we have an ordinance chasing a problem, and that problem may already be put to bed 20 minutes ago. So I'm not voting in favor of it. Thank you.
Thank you, Justice Wilson. I have Justice Stafford.
Thank you, Madam Chair. Well, the first thing I want to say is I don't want anyone to see my support of this ordinance as any sort of criticism or indictment of the current county judge's practices or anything like that. I had, back when I first got on the quorum court, I'd asked Judge Wood if we could get these names in advance, and we never got them in advance. I don't know why. But, you know, as J.P. Lopez said, you know, there's going to be, at some point, there's going to be a new county judge and a county judge after that. And we may be back here having this same discussion all over again. And so the quorum court passing ordinances is the way, you know, it's like with the planning ordinance in a way, to me. It's a way of saying this is the practice that we want to have here in the county. And it's already set out and laid out, and we don't have to, you know, keep rehashing it every 4 years or 8 years or something like that. The other thing is that I've had constituents come to me who've asked me, hey, who was that you voted to in favor of appointing at last night's meeting or last week's meeting? And I've been in the position before where I felt kind of embarrassed because I didn't even know how to spell somebody's name afterwards. And I'm like, well, I think their name is this, you know, and I've had to follow up on that. So, you know, to me, I'd be happy to even just get it, you know, even if I had a piece of paper sitting in front of me at the meeting that had the names of who were appointing to what, I'd be happy with that. And I can do my own research on who they are and things like that. But, you know, to me, it's because I've had constituents come to me and ask me these questions. And I want to give those folks whatever information that I can and let them know that I'm making an informed decision. So that's it.
Thank you, Justice Stafford. I have Justice Coger next. Justice Hires, you're not even on here. I don't know why. Okay, go ahead.
Thank you, Madam Chair. There was, Madam Chair, you mentioned something about that we could ask questions before we vote. We've never been able to do that. So I just wanted to have clarification on that. Did I understand you correctly?
Oh, thank you, sir. Anytime there is a motion on the floor to, if there's a nomination for approval, the motion is made, it's second, then you discuss it.
Okay.
So that's always the Robert's Rules of Order procedure to anything. And we can always ask questions while they're at the meeting. So the answer is yes,
Thank you for that clarification. That's
You're
very
welcome.
important.
it is.
Also, I want to say that the appointments that we make, those people make decisions that impact the county, that impact our constituents. I want to be able to tell my constituents why I voted yes or no for some appointment. Just voting no, that's not doing our job. And just voting yes, that's rubber stamping. So that's why this ordinance is important. And I will ask again that you please support this and pass it on. Thank you.
But we still, as a legislative body, have the final say of whether or not we accept or reject the planning board's decision. And there's been several CUPs where the planning board and planning department approved a project, and the JP said no. I have next on here, I have Justice Hires.
Thank you, Madam Chair. I agree with JP Wilson. This is a very reasonable request with very reasonable amendments. You know, it's our constitutional duty to approve or deny appointments, and I've been guilty of just going along with the thing and saying yes, not having a clue who I just voted for. And I know that this is not, you know, national level, like, appointments or anything, but, like, I cannot imagine a world where, you know, on the federal level, someone said, oh, no, it's okay, just appoint this person to the Supreme Court and vote for them because I think that I just can't imagine why we wouldn't just at least know someone's name and what they do. I don't understand why this is
But I
an
think the
issue.
fault is
I'm in the middle of
us
talking, but
and
that's
not,
okay. You can take the floor.
yeah. But I think the fault is on us for not asking, not on the information not being given. Well, go ahead, keep your mic on. If not, go ahead. We have Justice Lyons.
Thank you, Madam Chair. I agree, we need advance notice, and I appreciate the judge offering. He's made an offer, and I think we take him at his offer, that this will be put in the agenda packets and will come to us. Again, if it's not, then we should be able to discuss that and challenge that at the meeting as the members of the court. And so I'm willing to take him at his word, and if he falters, I don't expect him to, but if he falters, we can come back and address this in a month or so. So I won't be supporting this, but I'd like to call the.
We have, I already have mics on. I have got Justice Pond and Justice
But I make a motion
Lopez.
that we call the question,
We have a motion
to call the
to
question.
call the question after the discussion of, is this your second time to talk or your third time?
I'm sorry, Madam Chair, it's not the way that works. I got a motion, I got a second, we need it now. We need to vote on that motion.
You've already had two discussion times. I have a motion to call the question. And a second by Justice Lemming. All in favor say aye. Aye. All opposed say no. No. We're going to do a show of hands. All in favor, raise your hand. 1, 2, 3, 4, 6, 7, 8, 9. All opposed? 1, 2, 3, 4, 5, 6. The ayes carry. We're going to have end of discussion. Call the question. All in favor of? We're not going to do a roll call. Robert's Rules of Order says we can. Point of order. I'm still talking. You can wait. Robert's Rules of Order says during a committee meeting, we can either do it by voice. If it's not voice, that it's clear, then a show of hands is what we will do. So we either do show of hands so all in favor of the ordinance 2025, say aye. All in favor of the ordinance, the motion.
Are we talking about item 6.1?
No, we're talking about item number 7. It's the only thing that we're considering. All in favor, say aye. Aye. All opposed, say no. No. Show of hands. No, we're not going to do roll call.
Point of order.
We're not going to do roll call.
Point of order.
What is your point?
My point of order is that Robert's rules allow for a member of an assembly to ask for a roll call vote, and that's a right that we have, and I'm entitled to that, and the people at home are entitled to that. They are entitled. What if they can't see us raise our hands? But it's provided by Robert's Rules of Order. It's required.
Only if it's a division of the assembly. At no point in the committee meeting may a member request a roll call vote. All in favor, say, raise your hand. All in favor, say, raise your hand. 1, 2. She didn't. We're not going to do a roll call. There wasn't a motion. It's point of order. On the ordinance that was presented. All in favor, raise your right hand, or your left, whichever one you want. If you're in favor of ordinance 2025. 1, 2, 3, 4, 5, 6. All opposed, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9. The motion fails. With that said, we have a public comment time.
I just want to say quickly, I think all of our goals are to have the best men and women on any of our boards and commissions, and we'll absolutely do that. We'll put the information in the packet if it's ready. We'll also warn you guys if we have an appointment that didn't get out with the packet, maybe we had timing, we'll get that to you as soon as possible, even if up until the meeting, we can warn you guys and give you the background if it's not. I would also like to say, this ordinance was not discussed with my office at all before it was presented to you, ladies and gentlemen, and I want the public to know that too. If ever any of you have an issue with my office or things that we could do better, please reach out to us. We'd love to work on that and maybe come up with a solution before we get an ordinance drafted and have to move down that avenue. We just really love to talk to you like that. Thank you.
Thank you. Is there any other public comment? You have to get up there. State your name and address.
You got 3 minutes.
Time him.
Yeah, you're on the time.
Thank you.
My name is Silly Willie.
Yes,
and
it
I
is.
live at the far end of Washington County and Oklahoma line. But what I want to say to all of y'all, Patrick Deacon has done real good to me. He's called and asked me about members and asked me if I knew anybody that was real good on the board. And he ought to trust all of y'all like that. None of y'all shouldn't be trusted. And if y'all give a name out to an individual, be sure you had vetted him and know who it is. And another thing about putting somebody's name out here, you've got employees that work for, we had a deal that just happened to Washington County, and it was a horrible deal, and Patrick knows it was a horrible deal, and I ain't naming no names. But I had 15 employees call me about the guy that they put on this deal, and they just ragged him to death just because the employees wasn't happy with what he was doing. But that ain't saying he wasn't doing the right thing for Washington County. But it wound up being it wasn't the right thing, but it all worked out. But we can't just open this. I mean, you could have somebody come up here and sit on a board and take all kinds of cussings and fightings and arguments over $50 a meeting. They ain't nobody in Washington County wants to do that. And then you're going to bring them in and you're going to drag them through the mud and ask them to come up here and sit on this stuff. We can't do that. We just need to leave it alone. They've done a good job and they're going to continue to do a good job. But let's not put ourselves in a spot where we're going to get sued over more crap that don't mean nothing. Thank you.
Thank you, citizen. Lemming. Good evening. State your name and
Is it on? Can you hear me? Oh, hello.
There we go.
Yeah, my name's Casey Cromer, and it's really hard to watch this, I'd have to say. It's kind of embarrassing for our county, and I'm disappointed in our elected officials. And it seems that there's a lot of underlying personal issues going on with y'all being able to make a very simple decision of knowing information about someone you're going to vote on. It doesn't look good.
thank you. Is there any other public comment? Seeing that there's none, this meeting's adjourned. Thank you.